Akin, ẹ káàárọ̀, ẹ káàsán, ẹ sì kú ìrọ̀lẹ́. We greet you, our viewers, this morning, this afternoon, and this evening. That depends on where you are right now, watching us from. We'll be that in wo ìkànnì yìí ní wákàtí àbí ní ìṣẹ́jú yìí Akin pé ẹ káàbọ̀ sí orí ìkànnì yìí ní ẹ̀kan sí. We welcome you to this channel once again. God bless you. You are welcome. And as you all know that ọ̀rọ̀ Tani Olohun náà ti wà ní di a ti ń bá fa láti bí ọjọ́ díẹ̀ sẹ́yìn. So the issue has become a global issue. President ti di gbogbo nǹkan tí àwọn káàkiri àgbáyé lórí ọ̀rọ̀ kan tó ṣẹlẹ̀ ní lórí ọ̀rọ̀ Tani Olohun lónìí. Gẹ́gẹ́ bí a ti gbọ́ ní ọ̀sẹ̀ tó kọjá, ilé ẹjọ́ wọ́n tún jókòó lénìí láti gbọ́ ẹjọ́ pé ṣé ká fún Tani Olohun ní bẹ́ẹ̀lì tàbí ká má fún Tani Olohun ní bẹ́ẹ̀lì. So let us see bail, despite the fact that based on what the lawyers are saying, pé ẹjọ́ tí ó wà lọ́wọ́ Tani Olohun ó jẹ́ ẹjọ́ tí òfin fàyè gbà pé wọ́n lè fún ní bail. That was what they said, that the law said about the present case on Tani Olohun, that is a bailable offence. Now, the court sit today and the court rules. So application bail àwọn lawyer Tani Olohun did not fly. The adájọ́ ó kọ̀ ó fagilé bail application àwọn lawyer Tani Olohun. So all those things are the things that happened in court today. And the agbẹjọ́rò ti Tani Olohun àti ìjọba náà wọ́n sọ̀rọ̀ lórí the issue on ground, that what is the next thing to do for the Tani Olohun counsel. Kí ni ohun tó bá kàn? Wọ́n sọ fún wa nínú ìfìlọ̀wọ̀ tí wọ́n ṣe pé there are still steps to take that we'll be able to give Tani Olohun freedom again. So, but those things were not disclosed. One disclosed àwọn steps on my take. And another twist to this matter ni pé based on US man agbẹjọ́rò fún àwọn Òkútagídí lórí kọ́kọ́ tètè àwọn kan wá sí kóòtù ní ilé ẹjọ́ onígan, because ẹjọ́ tuntun ní ó jẹ́ ẹjọ́ ìbanilórúkọ jẹ́ ti CP Kwara State tó pẹ̀ Tani Olohun kan dá lẹ́nu. So lọ́ọ̀yà Òkútagídí náà wà ní kóòtù. Wọ́n sọ pé there was another case on Tani Olohun pé ẹjọ́ mi ti wà lórí Tani Olohun, but we are not giving the details of that new case that is on Tani Olohun. Based on what he said, that wọ́n ti lọ serve Tani Olohun ní paper ní court ní prison, but he did not accept that they were arguing on the way forward on that case before they came out to grant this interview that you just watched. So, but we are yet to know the details about this new case that is coming out, that has already descended on Tani Olohun. Pé ẹjọ́ mi tún ti wà nílẹ̀ fún Tani Olohun, àti mọ kókó àọ̀dẹ̀ tí mọ details ta ló pè lẹ́jọ́ tàbí kí ló tún ṣẹlẹ̀. So mọ̀ pé before the day runs out, in a couple of hours, we'll be able to know the details of this particular case that just come up again against Tani Olohun. So I want you guys to sit down and see and hear what the lawyers are about to say about this, the counsels to Tani Olohun and the counsels of Agidi tó wà ní court. Though the court did not hear it, but they are also the witness. They were also seeing what is going on in this court. So he came out to tell us the details of what actually happened in court today. So let us just hear from them. Thank you. Just sit back and watch.
Assalamu alaikum warahmatullahi wabarakatuh.
Alaikum salam wa rahmatullahi wa barakatuh.
Ẹ dákun mo fẹ́ kí ẹ dárúkọ yín fún gbogbo ará lílẹ̀ ní bẹ̀rẹ̀ ọ̀rọ̀ báyìí inshallah.
Orúkọ mi ni US Imam tí mo jẹ́ olórí ikọ̀ àwọn agbẹjọ́rò tó ń ṣojú bàbá wa Òkútagídí, àti àbí kí n sọ pé tí mo jẹ́ olórí ikọ̀ àwọn tó ń ṣojú Ògo Ìlọrin níbi kéèsì títí tòní.
Ká tó bọ́ sí kí ni adájọ́ wí. Mo kọ́kọ́ rí pé ẹ wọ kóòtù kan lẹ́yìn tó jẹ́ bí mo ṣe gbọ́ wípé kéèsì tuntun míì ó tún ti dé fún Tani Olohun.
Bẹ́ẹ̀ni.
Ǹjẹ́ ẹ lè kọ́kọ́ brief àwọn ará ilé lórí kéèsì tuntun ọ̀hún àti kí ni adájọ́ wí níbẹ̀?
Lè sọ nǹkan kan lórí rẹ̀. Mo wà ní kóòtù àmọ́ kóòtù yẹn ti ń jókòó lọ́wọ́ nígbà tí wọ́n wá pé kóòtù èyí tá a ti kó yìí ti ṣe tán so àti ìmọ̀ kí ni ruling kóòtù yẹn ṣe àmọ́ ẹnu nǹkan tí mo kàn gbọ́ torí ọ̀tọ̀ ní lọ́ọ̀yà tó ń handle yẹn a kàn lọ fún un ní moral support pé kó lè mọ̀ pé a wà pẹ̀lú òun la fi wọ kóòtù yẹn lọ lákọ̀ọ́kọ́ so wọ́n sì ń ṣe argument lọ́wọ́ lórí wípé nígbà tí wọ́n lọ sáàbù Tani Olohun ní correctional center lókè kúra kò gbà lọ́wọ́ wọn òun ni wọ́n á gbé application míì wá pẹ̀lú kí ni ọ̀nà àbáyọ tí ó fi mọ̀ pé kéèsì míì tún ti wà ní ọrùn òun ni wọ́n wá ń ṣe lọ́wọ́ tí kóòtù wa fi ṣetán láti jókòó láti jáde.
Alhamdulillah. Ìyún báwọn fún gbogbo ará ilé tí ń gbọ́ wa ká lọ síbi kéèsì tèmi gangan bàbá wa lọ́ọ̀yà US Imam. Kí ni tó ṣẹlẹ̀ nílé ẹjọ́ fún kéèsì tòní torí gbogbo ará ayé ni wọ́n ti wà pẹ̀lú mi báyìí tí wọ́n fẹ́ gbọ́ kí ni ń ṣẹlẹ̀.
Ní ìgbà tí a bá rántí níjẹ̀jọ́ a wà ní kóòtù yìí lórí ọ̀rọ̀ bẹ́ẹ̀lì Tani Olohun. Mo sì sọ níjẹ̀jọ́ yìí pé gẹ́gẹ́ bí lawyers tó ń sojú àwọn Ògo Ìlọrin àwọn ò lẹ́tọ̀ọ́ láti sọ̀rọ̀ lábẹ́ òfin kóòtù kan lè rí wa ni kò lè gbọ́ wa ṣùgbọ́n a mọ̀ fún ẹni tó jẹ́ lọ́ọ̀yà àti àwọn ọlọ́pàá a mọ̀ bá a ṣiṣẹ́ papọ̀ òun láti níjẹ̀jọ́ kóòtù wa sọ ruling application fún bẹ́ẹ̀lì Tani Olohun ti jẹ́ ẹjọ́ di òní so lónìí tá a wà ní kóòtù ṣe ruling lórí pé ṣé káwọn gba bẹ́ẹ̀lì rẹ̀ àbí káwọn má gba bẹ́ẹ̀lì rẹ̀ kóòtù sì rí i pé application tí wọ́n gbé wá ẹ̀bẹ̀ tí wọ́n gbé wá gan pé kò lẹ́sẹ̀ ńlẹ̀ kóòtù dànù ní ṣókí kò jù báwọn lọ kóòtù dá application wọn fún bẹ́ẹ̀lì rẹ̀ nù ni.
ní ká tó máa lọ lórí ọ̀rọ̀ yìí ẹ dákun ó yẹ kẹ́ ẹ lè ní ìmọ̀ràn kan torí pé ẹ̀yin lọ́ọ̀yà wa olùkọ́ ni yín fún gbogbo ayé ẹ̀yin náà lè máa ń kánsẹ́lì wa lérí ọ̀rọ̀ òfin ìmọ̀ràn wo lẹ́lẹ́ fún gbogbo ọmọ Nàìjíríà lórí ọ̀rọ̀ yìí ìmọ̀ràn wo lẹ́lẹ́ fún wa.
ẹyẹ ọ̀kan tá a ti ń fúnra wa ẹ̀hún láti bẹ̀rẹ̀ náà ni pé kí kálukú ọmọ tí ó mọ̀ sọ lẹ́nu torí pé kọ́dà kẹ sẹ́mi pé nu Al-Qur'an ó ní wala takifu ma laysa laka bi ilm inna sam'a wal basar wal fu'ad kullu ulaika kana anhu mas'ulan. Ọlọ́run lóhun ó bi wá Al-Qur'ani Ọlọ́run ní òun ó bi wá o ká má dúró lórí nǹkan tá a ní ìmọ̀ ń pa rẹ̀ nǹkan tí ó dá wa lójú Ọlọ́run kìlọ̀ fún wa nínú Al-Qur'ani láwa tí a jẹ́ mùsùlùmí tá a jẹ́ olùgbàgbọ́ òdodo gidi ntọ́ ọba ti nímọ̀ ń pa rẹ̀ má dúró lórí rẹ̀ tọ́mọ wa búra pé wàláhì mo mọ̀ sí wàláhì sojú mi tó sì mọ̀ sí Ọlọ́run lóhun ó bi wá àmọ́ kọ́ Ọlọ́run ó tó bi wá òfin táyé ń bi wá kódà bó ṣe jẹ́ òfin pàǹdà tó torí pé àwa táwa gbàgbọ́ nu ṣẹ̀ríà pàǹdà làwa ń pè ó sì níbi tó wúlò sí irú ibi tó wúlò sí ni irú eléyìí nígbà èèyàn kan lè jáde sọ nǹkan tí ò rí bẹ́ẹ̀ sí ẹnì kejì kò sì wá rò pé ó jẹ lọ kò ṣeé ṣe so òfin ti táyé gangan yóò béèrè ó ń béèrè lọ́wọ́ wa ká tó sọ títọ́ lọ́hùn tó kí gbogbo wa ká dáhùn ká mọ tí a mọ̀ sọ jáde lẹ́nu Ànábì ti sọ fún wa pé ẹni tí ò bá ti lè sọ dáadáa falẹ̀ yakul har auliyasu ẹni tó bá ti mọ̀ pé òun ò ní dáadáa lẹ́nu tó wọ́n sọ kó máa dákẹ́ kó dákẹ́ Ànábì ti sọ yẹn fún wa categorically náà kọ́ ẹlẹ́ẹ̀kejì ẹ dákun kí gbogbo wa ká sì pẹ̀lẹ́pẹ̀lẹ́ tá a fi ń ṣe láti ẹ̀yìn wá òun náà ní ká mọ̀ fi ṣe gbogbo ọ̀rọ̀ tí wọ́n ń pa níjọ́ níyì wọ́n lẹ́kọ̀ọ́ mọ́ wa wọ́n ṣe kinní kan àwọn òrókò àràwọn tó lẹ́kọ̀ọ́ àmọ́ àti àwọn aṣojú mi ti lọ rí commissioner of police wọ́n invite wa sì ti lọ àjẹ́ kó yé wọn pé àwọ̀ ọ̀mọ̀ sí gbà máa ṣàdéhùn pé a sì tún kùn lọ fáwọn èèyàn wa pé ẹnìkan kan mọ́ àrà sí wọn ẹ jẹ́ ká mọ bá a lọ bá a ti ń bá a lọ géèmù yẹn ń dùn lọ́wọ́lọ́wọ́ báyìí. Yes, that's why Mr. H0t.
Let me start with Sobi FM.
Okay.
Now,
pa kámẹ́rà náà tó lọ. Kò ṣe pa live la wà.
Can you tell us very briefly what transpired in court? Because we could recall that at the upper area court, a bail was moved for, the defendant. Today again, we had the ruling for his bail.
Okay.
And it was, of course, refused again. Putting the two together, can you just give a kind of breakdown?
No, you will recall that previous proceedings in the courts. Let me start from the upper area court. We argued about the issue of jurisdiction, and that court, that is the upper area court, assumed jurisdiction by its ruling delivered in the past. I can't remember the date, showing that the case before the upper area court is quite different from that of the magistrate court. So in fact, that of the upper area court is coming up tomorrow again. So the issue of bail there, that is before the upper area court, was raised orally, verbally, which we vehemently opposed on that day. Hence the necessity to come formally. That is, they should file their paper. They have filed their application. We have filed a counter to that. And that will be argued tomorrow. Now, as regards the magistrate court, which proceeding was just concluded, the bail was argued last week in respect of Tani Olohun. And the ruling in respect of that bail application was reserved till today, which has just been delivered. And the ruling of the court, that is the magistrate court, as regards the bail of Tani Olohun, was dismissed this morning for being unmeritorious and full of flaws.
Okay. All right. Can you speak more on reasons the bail application was released?
I just told your colleagues, let me call them your colleagues in Yoruba now, that at the magistrate court, the case is being handled by the police. And we have confidence that the police prosecutor, who incidentally is a supol and a lawyer, did well during the argument. One of the flaws discovered in the application was that the deponent to the affidavit in support of that application averred that he got information from the deponent, from the defendant, that is Tani Olohun, at the police headquarters on the 16th of August 2023. Whereas Tani Olohun was arraigned before the magistrate court on the 17th. He was arraigned and demanded on that day, which means he couldn't have gotten information on the 16th. Even though it could be a typographical error as pronounced by the court. But you see, you write it, you own it. You say it, you own it. So since that has been what was documented, there is no way out. Because Tani Olohun, as at 17th, was on remand at the correctional center, Okekura, and not at the police headquarters. So that fact, that information was absolutely not only incorrect but false.
All right. Can you give your full name, what you are standing for in the case?
Okay. My full name is Umar Saad Imam. People call me US Imam. I represent, you can see my team. I represent a team of lawyers for the nominal complainant. The nominal complainants here are the H0t Lori that instituted that case before the magistrate court, which came up this morning.
All right. And you represented what at the upper area court?
We represented Alpha Okutagidi. So that is just one man. In this case, it was a corporate body, a registered organization.
Thank you very much.
Thank you. You're welcome, sir. Yes, sir. Another one. Okay.
àwọn BBC Yorùbá ló fẹ́ béèrè.
Ǹjẹ́ ẹ lè ṣàlàyé fún wa ìdí tí wọn ò fi lè grant Tani Olohun ní bẹ́ẹ̀lì àti ohun tí àìfún ní bẹ́ẹ̀lì rẹ̀ ìtumọ̀ tó ní sí igun tiyín?
Orúkọ mi ni US Imam. Mo jẹ́ olórí agbẹjọ́rò torí pé mo ní àwọn think tanks tí wọ́n surround mi ní ẹ̀gbẹ́. So gbogbo wọn panupọ̀ pé èmi ni kí n lead tíìmù yìí. A sì ń sojú àwọn tó gbé ẹjọ́ wá sí magistrate court léyìí tó wáyé lónìí tí wọ́n jẹ́ H0t Lori. Wọ́n wà registered, but ìyẹn kọ́ ni ọ̀rọ̀. for now. Now ní ìjẹ́jọ́ a wá fún bẹ́ẹ̀lì Tani Olohun. And gẹ́gẹ́ bí practice ní sọ pé kéèsì ti magistrate court àwọn ọlọ́pàá ni wọ́n gbé wá. Àwa kàn lè help àwọn ọlọ́pàá. Kóòtù kàn lè máa rí wa ni, kóòtù ò lè gbọ́ wa. And tẹ́ bá rí the way tá fi mọ́ announce around that pé à ń watch brief for the nominal complainant. Nominal complainant lẹ́ni tó gbé ẹjọ́ lọ sọ́dọ̀ àwọn ọlọ́pàá. Àwọn ọlọ́pàá wọn wá gbé ẹjọ́ wá court. So ẹni tó jẹ́ prosecutor tàwọn ọlọ́pàá Supo Nasiru Yusuf lawyer lòun náà ó sì kájú rẹ̀ that is somebody I've known for almost or over 20 years. Now ó oppose bẹ́ẹ̀lì ẹ̀bẹ̀ fún bẹ́ẹ̀lì Tani Olohun lórí wípé ẹni tí ó ní Tani Olohun fún òun ní ọ̀rọ̀ tó ń wá sọ that is information tó ń present síwájú court ó sọ wípé 16th August náà lòun lọ gba information lọ́dọ̀ rẹ̀ ní police headquarter nílọrin nígbà tó ṣe wípé 17th August ni wọ́n gbé Tani Olohun wá sí kóòtù àtijọ́ òun ló sì wà ní prison ó túmọ̀ sí pé ọ̀rọ̀ tó sọ ń bẹ̀ wọn kìí ṣe wípé ọ̀rọ̀ ọ̀rọ̀ ni torí pé Tani Olohun Òkèkúrá ló wà ní 17th kìí ṣe police headquarter ṣe mo rò pé a ti gbọ́ yé so 16 lòun sọ nínú affidavit rẹ̀ ni pé 16 ni ẹni yẹn ń sọ ẹni tó depose sí affidavit in support of the bail application pé 16 lòun gba information lọ́dọ̀ Tani Olohun ní police headquarters mo rò pé a ti gbọ́ yé nísìn meanwhile 17 ni wọ́n àwọn ọlọ́pàá gbé wá sí kóòtù tí wọ́n ti remand rẹ̀ ní 17 so as at 17 yẹn ó ti wà ní Òkèkúrá so ẹni tó ti wà lókèkúrá ní 17 a lè gba information lọ́wọ́ rẹ̀ ní 16.
Okay.
No, 18th ni sorry 18th ni 16 ni wọ́n arrest rẹ̀ ni wọ́n gbé lọ police headquarters tó sunbẹ̀ mọ́jú so 18 lòun kọ 17 wọ́n gbé lọ sí Òkèkúrá 18 lòun wá kọ kì í ṣe 16 18 wọ́n kọ 18 ni wọ́n kọ pé àwọn gba information rẹ̀ ní police nígbà tó ti wà ní Òkèkúrá already so it would have been a different ball game tó wá sọ wípé 18 lòun ló gba information lọ́dọ̀ rẹ̀ Lókèkúrá tó sì sọ particular ọ̀rọ̀ lọ lórí yẹn náà ní kóòtù wípé tí wọ́n fi fún ní bẹ́ẹ̀lì nu.
bẹ́ẹ̀ adájọ́ ń dárúkọ pé tí wọ́n bá fún ní bẹ́ẹ̀ ó máa jọ̀ ń bẹ́ẹ̀.
àwọn argument nìyí hùn ìgbà tí kóòtù ń appraise argument both sides ní sọ wípé in fact ó lò against side wa ni wípé yóò jump bẹ́ẹ̀lì kò ní ṣọtí kò ní pé kò ní traceable address kóòtù sọ pé opinion ni tó sì tako evidence act ní tí kóòtù sọ ní eré àwọn alágbèyàn kalẹ̀
ní 18 yẹn gangan ni wọ́n
ní basis tí kóòtù fi fún ní.
kí wàá ní ìtumọ̀ tó ní sí igun tí ẹ̀yin ń sojú báyìí.
ó dùn máa wà ó dùn máa wà
lọ́nà òwúta
ó dùn máa wà púpọ̀ tí nínú Islam táwọn ń practice Ọlọ́run aláforíjìn ni ó sì máa fẹ́ kéèyàn tọrọ àforíjìn but àforíjìn náà tún ní condition anadama wọ́n ní pé èèyàn gbọ́dọ̀ regret action rẹ̀ so ẹni ṣe mọ̀ pé ẹni tí tó ṣe lọ́hùn tó tún wá tó tún brag tó tún fẹ́gẹ̀ pé èèyàn ti ṣe léyìí Ọlọ́run kò ní foríjìn so tí wọ́n bá tọrọ àforíjìn lọ́dọ̀ Ọlọ́run ó gbọ́dọ̀ regret action rẹ̀ ó gbọ́dọ̀ wà remorseful so ó simple ṣe mọ̀ pé ńgbà tí former ìyá Ọ̀ṣun tó apologize wọ́n sì foríjìn so téèyàn bá ti wá dúndò pé òun ò ní apologize ìyá Ọ̀ṣun Àbẹ̀bí ìyá Ọ̀ṣun Àbẹ̀bí ẹ̀fún ṣetán so ó ti apologize ó wà remorseful ó sì regret action rẹ̀ so wọ́n sì pardon rẹ̀ so tó bá di the next date hopefully kí wọ́n kàn lọ withdraw case títí ẹ̀ lókù but in this case ẹ mọ̀ pé kálukú dúró pé ok mi ò ní gbà ìwọ ò ní gbà nítorí ó dùn máa wà nù torí pé ruling tó ní favour àwa.
Are you saying in other words that if he's remorseful, apologize, there will be a way out, maybe settlement out of court?
Of course, as Muslims, of course.
Is that what you're advocating for, sir?
If they are willing for it, we are not averse to settlement.
Out of court settlement.
Out of court settlement. We are not averse to it at all.
Are you making any move towards this?
No, we sue them. We sue them. They are the ones who approach us.
But as a religious person, you will, of course, people say, you know, you don't want his death, you don't want his evil to happen to him.
No, not at all.
Repentance.
Of course. That's.
Is it possible to make the move from your hands?
No. We are aggrieved. We are the one injured. We are the ones armed by his utterances, and that is why we approach the court for redress. So if he is willing to retract, to apologize, then our doors are opened.
And if he's not willing?
If he's not willing, then we proceed with our case. That's why we are in court. Now let me briefly tell you this. There is another case between Muslim brothers. I was supposed to be at Ilobu on Sunday. That is 2 days ago. But unfortunately, I was not in attendance. Some of my colleagues, Bayero and Yaradua, were in attendance. So a brother of ours, a co-Muslim, has offended us. So we filed actions against him. So and he apologized. So and everything has gone now. The next thing is we go to the court and withdraw all our cases against him. That's just it. So simple.
Alhamdulillah.
I said, no, please. Okay, good, man. Now, maybe I should just start by speaking English. Now, I want to appreciate everybody for turning up to this session. Now, we are just from the court. We recall that last week we moved our application for the bail of Aziz Adebola Tani Olohun, and the ruling was adjourned to today. We are just from the court now. The court, in its wisdom, ruled that he will not grant bail to the applicant. Our application has been declined and refused. Knowing fully well that the offences for which he was brought to court are available. The law is there. All the 4 alleged offences are available. And the law is clear about that. Even without filing an application, moving oral application before the court should be able to grant the defendant applicant bail. But today we were shocked, and we were not only shocked, we were miffed that the court declined our application. Nta sọ ní pé ní ọ̀sẹ̀ tó kọjá a kọ̀wé lọ sí court pé kí wọ́n fún Tani Olohun ní bail nítorí àwọn ẹ̀sùn kan fi kàn àwọn ẹ̀sùn tí a lè gba bail ẹ̀ ni. Òfin dẹ̀ clear yéké lórí àwọn offences yẹn wípé a lè gba bail ẹ̀, they are bailable offences. Ṣùgbọ́n gbà tá a dé court lẹ́ni ó ṣe ni láàánú pé adájọ́ sọ pé òun ò ní fún ní bail. Ó lóun ò ní fún ní bail. And therefore, I don't know, but nta ṣe ṣìkù fẹ́ kẹ́ fọkàn yín balẹ̀. Nta ṣe ṣìkù lórí ọ̀rọ̀. Nta ṣe ṣìkù. A ní ìgbàgbọ́ pé Tani Olohun ó máa jáde. Àṣẹ.
Ó máa jáde, ó máa ní freedom very soon.
Àṣẹ.
Òfin sì tún fààyè gbà wá tó yẹ ká ṣe ó tún wà. Tó bá ti rí báyìí, nǹkan tá tún máa ṣe ó wà. Àwọn amẹ́tẹ̀ẹ̀ta ti foríkò. And we are going to take steps. Mo ti bá ọ̀gá mi sọ̀rọ̀, Ọlá sọ pé Ọládìpọ̀ SAN, mo ti bá sọ̀rọ̀. I ma take step immediately láti rí pé a gbé ìgbésẹ̀ tó kàn tí nǹkan bá ti rí báyìí. So, mo fẹ́ kẹ́ fọkàn balẹ̀ lórí ọ̀rọ̀ yìí. Ẹ má bára jẹ́ o. Ẹ má dẹ̀ fàyè gba jàgídíjàgan ní ọ̀sẹ̀ kejì sẹ́yìn tí wọ́n tẹ̀ tọ́jà yín, tí wọ́n bu yín, tí wọ́n lẹ̀ yín lóko, tí wọ́n fọ́ gíláàsì mọ́tò yín.
a rí pé ẹ pamọ́ra ẹ torí ẹ fàjọpọ̀ ẹ torí ẹ dàlú mo dúpẹ́ lọ́wọ́ yín títí dìsìn náà mo rọ̀ yín ẹ jọ̀ọ́ gbogbo ìpamọ́ra tá a ti ní lórí ọ̀rọ̀ yìí ẹ má jẹ́ kó dẹ́kun ẹ má jẹ́ kó sún yín ẹ má jẹ́ kó rẹ̀ yín ṣẹgbọ́ ní tí mo lè sọ lọ́wọ́lọ́wọ́ nìyẹn. That is the situation we have just faced in the court now. It is shocking and unbelievable that offences that are available have been rejected or denied. That is the situation we face now. We can just take 1 or 2 questions and we'll wrap it up.
For the benefit of people at home,
yes.
Do you think this is an upset in the judicial system?
Well, I can only say that it is already tried that the court has the discretion to grant bail or not, depending on the circumstance. And the discretion is unfettered, and that is the position of the law. It is discretionary. He has given the reason why he doesn't want to grant him bail. Those reasons are not tenable to us. And that's why I have just said we will exploit the next step in law, you understand, to avenge the situation.
Okay, sir, what is the fate concerning the case tomorrow?
No, tomorrow's case is another bail application. We are going to move it, another court entirely. Another court, another scenario. There are 2 defendants. In that case, there's Babatede is involved. So there are 2 defendants in the other court, in the upper area court. So different situation, different scenario. Tomorrow we will move the application for bail. It does not follow that what happened there will happen there. But you see, these 2 courts must grant him bail for him to get his freedom. These are criminal charges against him, and the 2 courts must give him bail before he can be free. And I promise that we will do the needful. Yes.
Excuse me, sir. Have they ever asked you about the character or his address or something before they said it's not?
No. We have not even gotten there. Okay. The police, the prosecution, alleged that he doesn't have traceable address and that he's not within jurisdiction, and many other excuses that police were hanging on. You understand? But then that is not enough. We have deposed an affidavit saying that he has credible shorties, he has traceable addresses. You understand? And that is enough. If the court have asked us to bring 2 shorties or more, we will have done that. We will have done that. We will have brought credible shorties to court to stand for him. Now let me tell you. You understand? Let me just say this. Well, we will do the needful in the law. It is not the end of the road. It is not the end of the road, please. I want you to understand. Now, I want to restrain myself from saying what I should not say in the public. Wọ́n ní nǹkan tí àgbàlagbà bá fi tó máa fi jẹ̀kọ́ abẹ́wé ló wà. So bó ṣe jẹ́ nìyẹn.
Ìbéèrè ọdún mo kọ́ fẹ́ bẹ́ẹ̀ lélẹ̀ má bínú. Níbi tí gbogbo àjọ fojú ní báyìí tí ọ̀rọ̀ dé tó yìí a ti rí i pé ọ̀rọ̀ náà ti ta kókó. Ẹ̀yin gẹ́gẹ́ bí lọ́ọ̀yà wa àmọ̀ràn wo lẹ fẹ́ gba àwa tàbí gbogbo àwọn èèyàn wa àbí kí lẹ̀yin fẹ́ kí ìrànlọ́wọ́ wo lẹ rò pé a fẹ́ lọ́wọ́ gbogbo olùgbé ayé báyìí tá a lè lọ ké gbàǹjarè rẹ̀ níbi tọ́rọ̀ dé tó yìí pé ìrànlọ́wọ́ báyìí la fẹ́ o bóyá Ọlọ́run lè járe àbámọ̀ tẹ́fẹ́ gbà pé gbèsè báyìí kọ́ o nìkan gbé o bíkọ́ ìmọ̀tọ́ ọ̀pá délé sìn ẹbí ajókòó ara ajókòó ọmọ ènìyàn ajókòó ṣòkìlà lè ṣe tí ò ní tako òfin tí ẹ̀yin gbé dání.
Ẹ ṣé gan fún ìbéèrè yìí yẹn. Agbẹjọ́rò àgbà Barrister Banks wọ́n ní kí n dáhùn ìbéèrè yìí. Ìbéèrè tẹ́ béèrè yẹn kò ń ṣe nǹkan tí ó yẹ ká dá yín lóhùn ní orí afẹ́fẹ́ ń bíbá. Nítorí pé nǹkan tí àwa rí ní ẹjọ́ ìní yìí, nǹkan tá a rí ní ẹjọ́ ìní yìí, èmi ò personally Tani Olohun lè rí justice mi lọ. Tí ẹlòmí ò bá fẹ́ sọ, èmi máa sọ. Adédàmọ́lá Ọlálékan Ṣólésì call to the Nigerian bar Tani Olohun cannot get justice in Ilorin because I've been able to feel the nerves of the police. They are unwilling to wait. They are unwilling to arrest these people even when they arrest us. I've been able to feel the nerves of the courts, both at the upper area court and the magistrate court. These people will continue to have their ways even up to the Court of Appeal. One Court of Appeal, Nibibai. So if you say you are going to appeal, we are still at the lower courts. We are not even yet at the high court. If we continue on this path, up to Court of Appeal, the client were Adegbola, Tani Olohun, Musibe. In my years of practice, anybody, any lawyer in Nigeria to tell me that what I'm saying is not right. I have never seen such a situation in my life. See, the law has moved on from mere technicality, slaughtering justice on the altar of mere technicality. What am I saying? The law, the criminal justice system in Nigeria has got to a situation whereby even when an accused person, somebody, a defendant that is alleged to have committed an offense which is not a capital offense, tí kò ṣe ẹ̀ṣẹ̀ tó pààyàn àbí ẹ̀ṣẹ̀ tó pé ó máa fún lé ní ẹ̀wọ̀n ikú àbí ẹ̀wọ̀n ó máa fún ní ìdájọ́ ikú àbí ẹ̀wọ̀n gbére. Tí ò bá ní lọ́yà gan, ó máa fún ní bail. Adédàmọ́lá Ṣólésì sọ bẹ́ẹ̀. I'm saying it to the whole world that the criminal justice system of Nigeria has evolved to the extent that a person alleged to have committed an offense which is not a capital offense, when it comes to court, when he's arraigned, when his plea has been taken in court and he has pleaded not guilty, whether or not he has a lawyer, they will grant it, especially magistrate court. Magistrate court. A magistrate court is not a superior court of record. We can orally take his bail the very day he was arraigned. It's from that inception that they have been dragging us back. But personally, what I thought was that they just wanted to keep him for some time before he gets the bail, not knowing that they don't have the intention whatsoever to release him.
It's okay.
Today we are witnessing a synergy of failure by the judiciary in Kwara State. I'm beginning to feel we are no longer in Nigeria, as if we didn't attend the same law school. What we are saying, simple offenses, simple. Look at it in their count charge. There's conspiracy. It's the only one standing trial here. What are we talking about? We felt, okay, we want to keep him so that he can show sign of remorse. For what in the first place? What has he done? What has he done? We have applied for his bail by virtue of the law. You said, okay, we should come officially. What is wrong in that bail but mere technicalities? Just to keep him, to continue to keep him in the detention. For what? For Christ's sake. We are calling on the judiciary in Nigeria entirely. It's very, very painful that the Attorney General of the Federation is from this state. Nothing has been done. There is a governor here. Nothing has been heard from them. So we are witnessing mere persecution here, and it is unfortunate. It is unfortunate. But we will just endure till we get our client out of the galley.
Thank you. Thank you. Inú mi dùn púpọ̀ láti gbọ́ ogun. Ẹ má bínú láti gbọ́ ogun tẹ́ ẹ sọ. Nísìnyí níjọ́ wo wá ní ìpàdé nílé ẹjọ́ tá a ti tán fún ọ. A sọ fún yín ọdẹ àmàdé sọ̀rọ̀ dé a sọ fún yín. A sọ pé a máa gbé àwọn ìgbésẹ̀ àti láà máa gbé àwọn ìgbésẹ̀ àdéhùn mọ̀. No, ẹ má wọ̀rí, a máa jẹ́ kẹ́ mọ̀ ṣẹ́gbọ́. A máa inform me in due course.
Sorry, sir. Can you talk to us briefly, very briefly, regarding what transpired in court today?
You came late.
Well, we have said it. The bail of the applicant was denied, and on technical ground. The offences for which he was brought to court are ordinarily bailable, and it is still subject to the discretion of the court. Surprisingly, the court has ruled in that way. He has declined jurisdiction. I mean, he has declined our bail application, and so we will take the next step.
Right, some party are actually looking for out of court settlement. Would you want to that part?
when the time comes, we'll look at it. We'll look at the merit.
All right. Just your full name and what you are standing for.
I'm Barrister Ademola Bank. With me is Olale Consolesi and Ole Odesoya. Standing for the defendant. Aziz.
Thank you.
Thank you. Thank you. Thank you.
Láti kàn ní BBC Yorùbá, ẹ jẹ́ lè sọ fún wa ìdí tí ilé ẹjọ́ fi sọ pé àwọn òdì fún Tani Olohun lómìnira.
Ilé ẹjọ́ sọ pé kò ní address àti pé kò lẹ́ni tó lè dúró fún, and these are opinions. Tó bá fún ní bail, tó bá ní ká lọ mọ ẹni tó lè dúró fún, á lọ mọ ẹni tó máa dúró fún wa. Wọ́n á dẹ̀ trace ilé ẹ̀, wọ́n á rí pé ó lá address, ó ní family. Abẹ́rẹ́ tó lókun nídìí ni kò lè sá lọ. Do you understand what I'm saying?
Ilé ẹjọ́ sọ kínní kan ní pàtó wípé wọ́n ti remand ẹ̀ ní 17 pé ohun tí ẹ gbé wá ni pé ní 18 ẹ lọ bá ní police headquarter.
Ṣé 17 kọ́ la ti wá sí kọ́ọ̀tù ni? 17 ni náà ṣe bíjọ́ ìnáwó ti detain ẹ̀ síbẹ̀ yẹn.
Bẹ́ẹ̀ wọ́n detain ẹ̀ ní 17 wọ́n wá sọ pé ní 18 bẹ́ẹ̀ sọ pé ẹ lọ bá ní police headquarter pé gba information lọ́wọ́ ẹ̀.
Bẹ́ẹ̀ àbúrò ẹ̀ lọ bá ṣé yẹn lè fẹ́ máa bá àwọn àfáǹsì ni and wọ́n deny bail, so is that what you want to ask me?
And that is not even enough.
Is that enough to deny him bail?
That is not even enough. In fact, if there is no application at all,
that's a needless error.
That is what we are saying.
It's okay. It's okay.
Without any application at all,
it's okay.
He's entitled to bail. That's what we are saying.
He's entitled to bail, with or without that. If we want to ban prison, any 17, àbí 18, àbí 19, the guy is entitled to bail. That's what I'm saying. Is that relevant?
Come on, lawyer rara. Come on, lawyer rara. Ni magistrate court too. Even if he doesn't have a lawyer at the magistrate court, I'm saying that he is entitled to bail. Without a lawyer at all, he's entitled to bail. That is what we have seen in our experience as legal practitioners.
It's okay. So, thank you. Babada.
Yeah, eléyìí ni èsì àbọ̀ àbájáde kóòtù ní ìlú Ìlọrin. Gbogbo ayé wọ́n fún Tani Olohun ní bail. Èyí ni àìsàn àbájáde fún wa ní bail.
Ẹ wo o lè rí justice ní bíbá yìí. Ẹ má sọ bá yẹn. Ìbàjẹ́ kan mọ̀. Tẹ́ẹ̀bá sọ ló bá yẹn kò lè justice ní bíbá yìí. Ìbàjẹ́ kan lè mọ̀. Tẹ́ẹ̀bá yìí lè sọ ọ́ sí.
Condition of bail ẹ̀dẹ̀ ń sọ fún wa wípé lè mítọ̀. Ẹ̀yẹ̀ méjì ni òwe ẹ̀kọ́ bá ẹ̀kọ́ ọ̀sán náà. Àwọn aláwọ̀ wá sí ọ̀sán náà.
Abilábì tó mú wa. Abilábì tó mú wa pé kò ní jọ́ọ̀pù bail. Ó máa mú ṣọtí wá. Ẹgbẹ́ ìgbàgbọ́ tó lè fi sọ àwọn kíní kan ní evidence àti ilẹ̀. Ṣé bẹ́ẹ̀ yìí ni kó mú ṣọtí ẹ̀ wá? Tí ò bá tẹ́ yín lọ́rùn. Tí ṣọtí yóò bá tẹ́ yín lọ́rùn. Ìyẹn ni kó mú mi wá. Èwo ni kẹ́ máa kẹ́ sọ kó wá dismiss the application.
Personally, you won't be able to meet up that, not be able to get your things. You understand? That is their presumption. And based on that presumption, they are denying bail. It's unfair.
When it granted, don't move and see any other state. Like it is state, so no state, one there, Oyo state, one there. Lagos state, one there. Can't be like other state.
It's not the way it is available in every part of the nation. So I'm relying on the authorities. Come on, man.